Good morning, everyone, and welcome once again to the DMH property seminars in what's happening in the world of property and planning. Thank you again for joining us this morning. For those of you who don't know me, my name's Emily Wood and I head up the real estate disputes team here at DMH Stallard. This morning, I'm joined by my colleague Jonathan Crook and I, who will talk about is commercial rent payable in a pandemic? Then we've got Morley, who's going to speak about what's happening long term in relation to the law of forfeiture and the government's potential plans to abolish the law of forfeiture. And then we've got Peter Rainier in our planning team, who's going to take us through his 20 years of working with Brighton Football Club, doing all of their planning work. If you have any questions on any of the topics, then please do use the Q&A function that you'll find on your screens. And then for any technical issues, please use the chat function and our BD team will help you there. So if I could have the next slide, please. So Jonathan and I are going to kick off, as I say, with talking about commercial rent payable in a pandemic. The question is commercial rent payable despite the recent pandemic forcing tenants to close premises and depriving them of, or at least some of them, of much of their income? Well, in 99% of the cases, the answer is yes, rent remains very much payable and the tenant remains liable for it. But what the government has put in place are a number of restrictions on the landlord's remedies to take action for arrears. They don't write off those arrears. There is no moratorium on the liability for rent, but just certain restrictions on what the landlord can do. So looking very briefly at what those restrictions are that have been in place for most of the lockdowns and indeed are still in place till the end of June this year. We've got the ban on forfeiture for arrears, so commercial landlords cannot forfeit for commercial rent arrears, and that will last, as I say, up to the 30th of June 2021 at the moment. Got a ban on statutory demands and winding up petitions for landlords in relation to arrears, and again up to the end of June. And we've got effectively a ban on the exercise of commercial rent arrears recovery, sending in the bailiffs to recover goods to the value of the debt, and again till the end of June. So they're all in place in terms of what landlords can't do in terms of rent arrears. We've also got a code of practice for commercial property relationships, which has recently been updated by the government, which effectively introduced last summer in response to the pandemic, encourages negotiations between landlords and tenants in relation to rent arrears and ongoing lease terms, and encourages a greater sharing of information. We've seen the code referred to a lot by both tenants and landlords throughout our dealings with clients, to varying degrees of success, certainly by tenants trying to push landlords to negotiate where they seem unwilling to do so, and by landlords to encourage tenants to provide frank and up-to-date financial information on their circumstances. But the code is very much voluntary and therefore to some extent not necessarily effective. So if I can have the next slide, please. The only real option at the moment for landlords to recover arrears, and therefore the only real threat against tenants who remain liable to pay their rent during the pandemic, is debt proceedings. So issuing a claim, the landlord issues a claim for the arrears against the tenant in either the county court or the high court. This particular procedure used to be almost a last resort for landlords. It was seen as a lengthy and fairly expensive process. But as the only current option, we've seen a massive increase in its use. And the courts have been basically flooded with these types of claims. The British Property Federation has estimated that there is currently about 7 million rent arrears as a result of the pandemic. So as you can imagine, with this being the only option, it's obviously very popular. So we've been waiting for some of these cases actually to be heard by the High Court to see how the courts are going to react to these claims by the landlord. And we had two almost in quick succession, the judgments given in April this year. We had Commerce Real against TFS Stores, so that's the Westfield shopping centre against the Fragrant shop. We've got the Bank of New York Mellon against three quite different tenants, Cine UK, obviously operating a cinema, Mecca Bingo, a bingo hall, and Sports Direct, a retail unit. In the case of all of these tenants, they had to close their premises during the pandemic, or some of them were allowed to open briefly, but they all said that it was just not commercially feasible to stay open. And they had not paid any of their rent, or the majority hadn't been paid since March 2020. So the landlords brought a claim against all of these tenants for the full amount of the arrears, together with interest and legal costs. And the tenants really did throw the kitchen sink at it in terms of every defence that they could think of, or their lawyers and legal team could think of, to defend the claim for the arrears. But every single argument failed, and the landlords were successful in recovering the arrears or getting an order for the arrears in all these cases. So in terms of the arguments that they used, as I say, they really did throw everything at it. First of all, between them, they argued that all the restrictions that had been imposed by the government to effectively protect tenants throughout the pandemic against any claim for arrears, whilst they tried to recover from the economic downturn, should itself have prevented debt proceedings as well. And although it didn't specifically, this was just a loophole that the landlords shouldn't be able to use. The tenants also argued that the clause that you see in most leases, whereby the rent is ceased while the premises are damaged or destroyed, should also apply where the premises cannot be used, where there's no ability to trade from the premises, not just in the case of where there was actual physical damage. And the tenants went on to say, even if the actual clauses didn't cover this scenario, then it should be implied into every lease that where the premises cannot be used and it would be illegal to trade from them, that rent shouldn't be paid. They also argued that in terms of the insurance that the landlords had got to cover loss of rent, the landlords were obliged under these leases to get loss of rent insurance. And of course, the tenants were paying for that via insurance rent, that because there was this insurance in place that landlords could rely on, the tenants shouldn't have to pay their rent, and the landlord should instead turn to that insurance. They also argued that the code of practice that I mentioned at the outset, that the government had put in place encouraging landlords and tenants to negotiate over rent arrears rather than pursue claims, should take precedence, and the landlords in these cases hadn't made any effort or sufficient effort to try and negotiate, but instead had issued court proceedings. And then finally, the tenants came up with some very complex and technical arguments about how the tenants during lockdowns had been faced with this unpredictable scenario of not being able to use the premises, that the leases were therefore frustrated because the whole purpose of the leases was to allow the tenants to trade from these units, and it had become illegal to do so, and therefore the leases should effectively be brought to an end. None of these arguments failed, however clever they were, and the court dismissed them all. The points that the court particularly emphasised were that the pandemic and lockdowns weren't unforeseeable. A pandemic is not unforeseeable, so it didn't frustrate the leases. It could have been predicted. In fact, the landlords had obviously got loss of rent cover, but also the tenants could have taken out their own insurance against rent payable during a pandemic. They also said that in terms of that loss of rent cover that the landlords had taken out, the rent wasn't actually lost because the tenants remained liable to pay it. So it wouldn't have in any event been covered by landlord's insurance. They also said that a pandemic did not cause physical damage to a premises. So the rent cessation clause just didn't apply and wouldn't have kicked in, and there was nothing implied over and above that. They made the point that the code of practice was voluntary, and whilst the landlords were encouraged to negotiate with their tenants, they weren't obliged to, and that they could issue debt proceedings nonetheless. And all these arguments about the frustration of the lease and the fact it was illegal to use the premises. The court made the point that the pandemic has only temporarily closed premises, and therefore the leases do serve a purpose going forward once the premises can open once again. So as matters stand, I think we're going to certainly see more landlords pursuing tenants for unpaid arrears despite the pandemic. The courts have really given the green light to landlords to be able to pursue these claims. And there's going to be very limited defences that haven't already been tried and tested in these cases that the tenants are going to be able to pursue. What's also worth noting is that the landlords are also able to claim interest on these arrears if there is an interest clause in the lease, and they can be certainly higher than your market interest rate, so tenants need to be warned of that. Next slide, please. In terms of then looking forward, what comfort is there for tenants, or what might we see tenants trying now that it's clearly stated that debt proceedings can work? Well, the government has brought into effect this moratorium under the debt respite scheme, breathing space. It came into effect on the 4th of May this year. And basically, although not intended, I don't think, to protect commercial tenants from paying their rent, in theory, it is possible for an individual rather than a company, because it doesn't apply to companies, but an individual commercial tenant to rely on it. And they would need to basically apply for a moratorium via a debt advisor. And that advisor would apply itself to the insolvency service if it's satisfied that the tenant can genuinely not pay its rent, pay its debts. And a moratorium would then be put on a register, which is held by the insolvency service. The insolvency service will then notify the creditor of that debt, so in our scenario, the landlord, and then the landlord is prevented from taking any action to pursue that debt. And that would include if he had, for example, issued debt proceedings already, he would be obliged to notify the court that there is a moratorium in place and those debt proceedings need to be stayed. The length of the moratorium is ordinarily 60 days, and there are various obligations that the landlord has to comply with during the moratorium as soon as it's received notice that it exists. The landlord doesn't need to do anything unless it receives notice, but if it does, it needs to, for example, notify the insolvency service of all of the rent and other amounts that are due from that particular tenant. So we'll wait and see how many commercial tenants apply for this moratorium, because it is, as I say, fairly new. We've also awaiting the outcome of the government's call for evidence. So the government sent out a call for evidence to landlords, tenants, investors, all property professionals, which was due to be returned at the beginning of May. And we're waiting to see what the government's response to that is. They were asking landlords and tenants how they're currently dealing with this potential £7 million worth of rental debts that are out there in the market, and asking how both tenants and landlords thought the government should act now to best promote economic recovery. The paper raised a number of scenarios and asked for comments on it. And those scenarios included whether the current restrictions against forfeiture, insolvency and commercial rent arrears recovery should simply expire on the 30th of June and there should be no further protection, or whether some should continue to exist and be extended and others lapse. They also raised the scenario that certain businesses should be helped particularly, and yet others should be continuing to pay their rent. And they also raised the scenario that there should be some form of encouragement of mediation or adjudication between landlords and tenants, so that it didn't all reach the courts but could be resolved more amicably. I don't think it takes a genius to guess that most landlords will be replying to this call for evidence saying that they want the restrictions lifted, and most tenants will be replying saying that they want the restrictions either simply remaining in place or indeed strengthened. But I think even if the restrictions are lifted, I don't think any of us imagine that every landlord out there is suddenly going to be forfeiting every commercial lease where there are rent arrears, because obviously there's going to be voids in the market that they then will have a risk of. So I'm now going to pass over to Jonathan, who's going to have a look at how to prepare leases effectively for the future, for a further pandemic, heaven forbid, that's where we find ourselves. Jonathan.
Thank you very much, Emily. Good morning, everybody. I'm Jonathan Crook. I'm a partner in the commercial property team at DMH Stallard. I'm going to move on from what Emily's talking about to then focus on the transactional element of this tricky issue. I've touched on this in a previous seminar, and I'm now going to broaden it out a bit. It is incredibly topical. I'm finding this crop up in many, many leases, both brand new leases and renewal leases. It's not just one type. So it's in both new leases and 54 Act renewals. I think the first point to make is this is really new territory for all of us. Before March 2020, I don't think I'd ever seen a lease relating to a clause relating to pandemics in a lease, and I doubt many of you would have done. It really is brand new. We're all feeling our way to some extent. And one difficulty here is that there's no standard wording for this. These are all new, there's new drafting. It's not like a repairing clause where we're all used to know what that should say. This is absolutely new territory, and we're all feeling our way to some extent. So what we're mainly talking about is a government measure, meaning the tenant can't use the property. And the tenant is saying in those circumstances, they shouldn't have to pay the rent. So I'm going to assume for the next slide or so that the landlord is prepared in principle to allow that. Then I'm going to talk a little bit about some of the considerations the parties need to take into account. So first, should the clause just cover COVID-19? Should it cover other diseases? Most of the clauses I have seen have covered COVID-19 and other pandemics. That seems to be fairly standard. Now, importantly, what percentage of rent should be suspended? I think it's important we don't just assume it'll be 100%. I've seen 100% rent suspended. I've seen 50% rent suspended. It all depends on what the parties can agree and on the bargaining strength of the parties. So that's something where the agents among you who are watching will really be able to help us, and you'll be seeking to agree what percentage of rent will be suspended. Should the suspension apply to the rent, or should it also apply to the service charge or even insurance premiums? Well, in my view, it's pretty standard that if it's going to be agreed, it'll just be the rent. Service charge tends not to be suspended. Again, it's a matter of bargaining position. And I think insurance rent would be very unusual for it to be suspended because the landlord clearly has to carry on insuring the property. Next slide, please. One technical point I've come across is, well, what happens if let's say we're talking about a shop or a cafe is closed by a rule of the government, but because the tenant has done something wrong? You have heard of these cases in the news where a cafe, for example, has been forced to close because it has not been COVID compliant. It hasn't been complying with the rules. Well, in those cases, I would argue from a landlord's point of view, the tenant shouldn't have the rent suspended. It's the tenant's fault. It's not a general lockdown there. It's that particular store has had to close, or cafe. I haven't seen that much in the drafting, but I think it's worth thinking about, albeit I would hope it's not very usual. Should there be a long stop date? Should the rent be suspended for a particular time and then start to be paid again? Should there be a right for either party to end the lease if the lockdown lasts a long time? Again, a matter of negotiation. And how often does it apply? We've had, I think, about 3 lockdowns so far since March last year. Should the rent be suspended every time there is a lockdown? That's what I've seen in most of the clauses I've come across, but you could argue that it shouldn't happen every time. The tenant might get 1 or 2 goes at it. Let us hope very much we don't see very many of these lockdowns, but it might happen as it's happened before. Subsidies is another interesting point. I've seen clauses that say that where the tenant receives some sort of subsidy or grant from the government towards the rent, then that should be taken into account when agreeing the rent suspension. So let us say the parties had agreed 100% rent suspension. If the tenant receives a subsidy from the government for £100 a month towards the rent, then it would seem fair that that is paid to the landlord, notwithstanding the suspension. From a tenant's point of view, I would make clear here that when we talk about subsidies, we're not talking about rate relief, if there is any. We're talking about payments by the government towards the rent. One point I think it is worth being careful about is tenants' heads of terms. I've come across a few cases recently where tenants have been producing heads of terms. Often this will be where a tenant is a large retailer with lots of shops. And I found that you might see a repairing clause in 2 lines, but then you might see half a page dealing with the pandemic, and that will be very carefully worded legal wording in great detail about when the rent should be suspended. That's quite unusual, I think, for heads of terms. I think we need to be a bit careful as a landlord that that isn't just accepted without looking at it in detail. If it's accepted at heads of terms stage, it's always difficult for the lawyers to sort of backtrack on it later. Just to give you some examples, I've seen heads of terms where the tenant has said that all their obligations are suspended during a lockdown. And I think that goes too far. From a landlord's point of view, I've seen circumstances where tenants have said there should be a rent suspension if some of their staff are ill or if their supply chain is affected. So not actually a lockdown, but an effect of a pandemic. Again, I think that's very wide, and I wouldn't commend that to landlord clients. So just a thought for the surveyors agreeing heads of terms, it may be worth involving the lawyers at an earlier stage than normal to ensure you're not caught by heads of terms that later you might want to change. And just another thought, when agreeing these terms, landlords, I think, will need to have advice from their surveyors, their valuers, on whether these clauses might have an effect on the value of the property. I imagine that's new territory for everybody, but it must be a possibility. I'm not a valuer, but it's worth thinking about landlords taking instructions from their surveyors as to what effect they might have. Can I have the next slide, please? Okay, moving on to a case now. You may spot immediately we're in the same place as Emily was. We're in the Westfield Centre in Shepherd's Bush. Quite a litigious place, clearly. My case is a recent one between WH Smith and, again, Commerce Real Investment, the landlord. WH Smith had a large shop in the Westfield Centre. We're talking about renewal proceedings, so the tenant served a Section 26 notice under the 54 Act. The landlord did not oppose the lease, and most of the terms were agreed between the landlord and the tenant. Interestingly, without going to the court, the parties had agreed there would be rent suspension in the event of a lockdown, a pandemic, and it was agreed it would be 50%. And just looking back to what I said a minute ago, the tenant had to account to the landlord for any government assistance it received on the rent. So most of the terms were agreed. And just as a reminder, in the Landlord and Tenant 1954 renewal proceedings, if a party wants to change a term from the existing lease, that party is under a duty to justify that under the OMA case. Now, the only question left for the court in this case was, what was the trigger for the pandemic rent suspension in the new lease? What should actually start that suspension? Next slide, please. The parties had different views. The tenant said it should be the closure of non-essential retailers. Now, that wouldn't here include WH Smith. Now, the point was WH Smith had been required to stay open. They had a post office in there, so they had to stay open. And for me, I have to say, I found this very useful. Where I live in Haywards Heath, WH Smith has been open. It's been jolly useful during the various lockdowns. They also had a news agent, and I think that probably meant they could have stayed open anyway, but the post office meant they had to. They had no furlough support, and they pointed out the footfall in the centre had been reduced dramatically, unsurprisingly. Their sales had dropped by about 90%. Their argument was the tenant had been deprived of virtually the whole benefit of occupation, even though it had stayed open, and that in the new lease, the trigger should not be whether WH Smith was forced to close, but whether non-essential retailers were forced to close. For example, Waterstones or Next, if they had to close, even though Smith stayed open, Smith wanted to have a rent suspension. Well, the landlord disagreed, and the landlord said the trigger should be if the actual tenant was required to close the property. So if WH Smith closed the property, now clearly that wasn't likely to happen. The landlord said the tenant had a competitive advantage. It could still sell its books, whereas Waterstones couldn't from its shop. Next slide, please. So it's a county court decision, and the court held that any benefit to the tenant of actually remaining open in a deserted shopping centre was more a notional benefit than a real one. There was hardly anybody in the centre, and the facts we just looked at about how the footfall had dropped dramatically was saying that the tenant had really had little benefit of staying open. There was the competitive advantage. I don't think the court was persuaded by that. So the court said the trigger for the pandemic clause in the new lease should be the closure of non-essential retailers. So if there was another lockdown with a new lease in place and shops like Waterstones had to close, then Smiths would obtain their rent suspension even though they stayed open. Interestingly, the court also said if the parties hadn't agreed the inclusion of a rent suspension clause for pandemics, then essential fairness would demand the inclusion of that clause. I thought that was an interesting comment. It's a county court decision, but it's an interesting comment on how that judge felt new leases should be drafted. Next slide, please. Another interesting point about the case was the judge held that there wouldn't be an uplift in the rent in the new lease because the pandemic rent suspension clause was, so the judge said, something that all tenants want and that the market has now priced it in. It's an interesting comment, and I'd be interested to know what the valuers among you and the agents among you think about that. But there was no uplift in the rent. It was something that was becoming standard according to the court. It's a county court case. It's not binding on future cases, but it's certainly an interesting example of where we're going. It might have been different if the shop had been in the high street, as there might have been more chance for passing trade rather than in the shopping centre. But I think, again, the case shows that these clauses are becoming more mainstream. And as I said, I'm finding them crossing my desk a lot now, both on new and renewal leases. And once we're able to get together again, I'll be very interested to hear from the agents of your experience of whether these clauses are being insisted upon by tenants. Well, thank you very much. I am now going to pass over to Lawrence, who's going to talk to you about forfeiture.
Thank you very much, Jonathan. Good morning, everybody. For those that don't know me, my name's Lawrence Morley. I'm an associate in the firm's real estate dispute resolution team. I'm just going to spend 5 minutes of your time today just talking about the potential abolition of the current forfeiture regime. Next slide, please. So just to start things off, what is forfeiture? Well, in circumstances where a tenant has defaulted on its obligations under a lease, forfeiture enables a landlord to take steps to terminate the tenancy. In order to be able to forfeit a lease, a landlord firstly needs to establish the basis of their right to do so, and the most common way they do this is to rely on a specific clause in the lease which grants the landlord the right to forfeit in certain circumstances. So what is the current position? Well, currently, forfeiture can take place either by a landlord issuing and serving possession proceedings or by them taking some other unequivocal action, for example, changing the locks in a commercial context to demonstrate the termination of the tenancy. And this is commonly known as peaceful re-entry. If a tenancy is forfeited by either of these methods, then the tenant or leaseholder or a subtenant or mortgagee may apply to the court for relief from forfeiture, and if they are successful, that would have the effect of reinstating the tenancy. So why now for a possible change? Well, in 2006, so quite a long time ago now, the landlord first looked at this and produced a draft bill that proposed to abolish forfeiture and replace it with a statutory termination scheme. Now, nothing progressed at the time. As I say, 2006, a number of years ago now. but it appears that the Law Commission are now looking to resurrect this. And given the passage of time, they've sent out a recent survey asking for comments, and the deadline has just passed. And I and a number of my colleagues, I suspect, have put responses into that. Next slide, please. So one would imagine that when they get their responses, the Law Commission will review the submissions and may make some amendments to the draft bill if they think necessary, and then we'll see what the actual change is thereafter if the government decide to push forward with this. But for the time being, I'll just briefly go through what the draft bill as it currently is proposes. So as I've said, it will replace forfeiture, so forfeiture will be no more, and it will replace it with two forms of statutory termination. Form number one we'll call the standard procedure, which is a court-based termination claim, and that is where if a tenant defaults on its obligation in the lease or an obligation in the lease, for example, to pay rent, the landlord will firstly have to serve a default notice on the tenant, requiring them to remedy the breach. If the tenant doesn't remedy the fault, then the landlord can apply to court for a termination order. Now, this is similar to the current system, whereby if the breach is for anything other than the non-payment of rent, a landlord must serve a Section 146 notice on the tenant before issuing proceedings. So the main difference with this proposal to the current system is that it doesn't matter what the breach is. For any breach, the landlord must serve notice on the tenant before taking them to court. So even if it's non-payment of rent, still have to serve notice. The second form is what's known as the summary procedure. And this is a supposedly accelerated process, so quicker than the standard procedure, to replace peaceable re-entry. So again, if the tenant is in default, the landlord has to serve notice, this time a summary termination notice on the tenant. And this has the effect of bringing the tenancy to an end 1 month from the date of service, unless the tenant applies to court to discharge the notice. So landlords will immediately notice that, and possibly be disappointed by the fact that the peaceable re-entry under the current system, if this proposal is brought through, will be removed, and that will possibly be a disappointment to some, given how effective and immediate it can be. Indeed, if you look at the summary procedure, which replaces peaceable re-entry, that immediacy is gone because of the requirements. Effectively, it's a 1 month notice period. If the tenant does nothing within that month, then the lease or the tenancy will end. But effectively, they have a 1 month grace period to decide whether or not to challenge this and ask the court to discharge the notice. So it could be that a tenant waits right until the end of the month and then makes an application. Also, as currently drafted, there is no requirement for the tenant to give notice to the landlord of their challenge. So assuming there are no amendments made, it may be that the landlord doesn't actually know whether or not their tenant has applied to court to discharge the notice after they've served a summary termination notice on them. I would have thought that this will be something that will be amended if and when this bill becomes law, and I think an easy fix would be to require notice to be given to the landlord, but we will wait and see. So that's it. That's all from me. It was only a few minutes. Those are the proposals in a nutshell. We will wait and see what happens. As I said, it was first brought up quite a long time ago. Hopefully the governments, if they are planning to reform, won't wait quite so long. So it's just one to watch out for, really, one to keep your ears to the ground. And if there are any changes, then please do look at our website, as I'm more than sure that either myself or a colleague of mine will be blogging about it to keep everybody up to date. So that's it from me. Thank you very much. If you've got any questions, pop them in the Q&A, and I can answer them at the end, or come to me after the seminar. I'm going to pass over to Peter now, who's going to talk about his interesting work with Brighton and Hove Albion Football Club. Peter.
Good morning, everybody. Good morning. I'm going to just give you a little bit of an insight. I'm not sure if the title, I can live up to the title, but let's give it a go on the next slide, and I'll just introduce what's been 20 years, as has been said, of work with the football club since 2001. For those of you that are Brighton Hove Albion aficionados, you'll realise that if you take yourselves back to the late 1990s, the club were just literally seconds away from extinction from the Football League, moving down into the conference. And at the same time, they'd had their grounds sold at the Goldstone ground in Hove. And they'd also therefore been exiled to Gillingham for 2 years. So the state of the club was really quite perilous. And probably my 100 to 1 is my sort of estimate of what you'd have got if you went into a bookies and asked, well, what odds against in 20 years' time Brighton being in the Premier League with a new ground? Because I think you would have got something like that in terms of odds at the time. When I joined DMH, DMH were already working for Brighton Hove Albion, and they were already secured their planning permission for them to operate and play at Wisdean, which they did for a few years. There were various strange planning conditions added to that consent, including one which said that there could be no music played other than one song before a game, which had to be good old Sussex by the Sea, of course. If you're a Brighton fan, you'll know it well. So planning was part of Brighton Hove Albion's journey, really, right from the beginning. But I'm going to talk to you really about people, I think, primarily, and particularly really just a little bit about my early days at DMH, when I first went to Falmer to look at the ground, look at the land, and see where the planning permission was going to be forthcoming. My views on it, whether it was going to be forthcoming for the new ground there. People are critical to make things happen, I think. And next slide, please. The list, you'll know a number of names on this list, probably, but Jonathan Clay was the barrister, and late Tony Allen was the legal brains, really, behind seeing us through a number of public inquiries. When I first joined, I went to view the site with Jonathan Clay and all the consultants that were part of the team, so transport, landscape consultants, ecologists, and the like. And we all went down to the site, and then had a meeting back at our boardroom, actually, in Brighton later that day, to run through what the scheme was. Jonathan, when we went to the site visit, Jonathan turned to me and said some words to the effect of, "This is going to be challenging," which in my view is barrister speak for, are you really sure about this? This is going to be really, really difficult to get permission through. So Jonathan was very important in seeing us through all those public inquiries alongside Tony. Martin Perry is well known to many people. He was chief executive at Brighton for many years. When we got back to that conference room, Jonathan Clay asked all of the consultants in the room to explain what they thought was the most difficult aspect of the scheme from their discipline's point of view. And there were probably 10 or 12 of us in the room, and we went round and explained what we thought was our weaknesses, really, in terms of our case. And I have to say, there were quite a lot of them. That there was the impact on the area of outstanding natural beauty, that the fact that the site was going to become a national park. There was the issue of impact on listed buildings at Sussex University and Falmer Village. There was the impact on just the countryside, the view from various viewpoints. And we went round and we all said a variety of things. There were planning policies that weren't aligned to the scheme as well at the time. And it reminded me a bit of the 12 Angry Men film where we all went round and had our say and said how difficult it was. And it got to Martin Perry. And those of you that will know him, he then spoke for probably 40 minutes without a note, and said, and really just brought us all round to believing the enthusiasm that he had for the scheme, and the answers he had to all of our criticisms or all of the difficulties that we'd raised. Was quite inspiring, really, and I think that was key to seeing the scheme through and seeing Brighton develop to where it is today. Dick Knight was the chairman of the club. He had a background in advertising, and he worked with Falmer for All, led by Paul Samara, on a number of initiatives, number of noteworthy initiatives, including sending 92 red roses to John Prescott, the then Secretary of State, on Valentine's Day, to again emphasise the case that we were one of the 92 league clubs and we're the only one without a ground. As I said, we had a number of inquiries, 4 in all, in terms of planning. So there's a local plan inquiry trying to get the site allocated in Brighton's local plan. There was the planning appeals for the planning applications that we'd made that had been approved by Brighton but refused by Lewis because the site was on the boundary and both authorities needed to approve it. So that went to a public inquiry and was called in by the Secretary of State. There was also the South Downs National Park inquiry looking at where the boundary was going to be of the national park. And then there was a judicial review, and there was a sort of reconvened part of the inquiry which dealt with alternative sites that could have been used for the stadium, which included some strange ones, including building out in the sea at Shoreham Harbour, amongst others that we looked at. So they were the important people. What we ended up with ultimately was planning permission. It took many years, and was actually granted in 2008. The stadium we began building the stadium. It was finished in 2011 for the first for that 2011-12 season. It was a highly sustainable stadium. I think that was one of the key factors which meant that we were successful. It was cut into the ground significantly. There were 138,000 cubic meters of chalk which had to be removed in order to sink the stadium down into the ground and make it less visible than it would otherwise have been. We then had the issue of what we were going to do with that chalk, and ended up with a scheme of putting it on the neighbouring fields to the south, which meant another planning application. But it meant that 22,000 lorry loads of muck away did not have to take place, and obviously there was a significant cost saving with that. Next slide, please. And then just run through quickly a few of the other schemes that Brighton have been involved in. So the training facility was a state-of-the-art training facility. The stadium cost, I think, around 120 million. The training facility was around 32 million. It's an amazing facility. There's everybody there from the academy upwards to the first team. And if you look at that Y-shaped picture and begin on the left-hand side and imagine that left-hand wing of the Y is the academy, and you go from under 10 changing rooms to upwards through to under 15s and 16s and 18s, and then you go through the entrance and you either, unfortunately, if you're not quite good enough, leave, or you go across into the right-hand side to the second team, first team, development squad, etc. There's a new building being built there for women and girls facilities, and there's an extension currently under construction, nearly completed, which has pushed that dome, that white building you see in the picture, further southwards and extended the training facilities yet further. Next slide, please. And then the hotel, we had a scheme for a hotel on land adjacent to the stadium. This is the only scheme that we've had refused in many years of many applications. So 150-bed hotel was only lost on the casting vote of the chairman of Brighton Hove Planning Committee. It still riles somewhat with myself and Martin Perry that was the case, but we move on. Next slide, please. And then some of you will know, some of you may not know, that Brighton were also involved in the land to the north of their training ground. In that slide, you see the training ground in the bottom left-hand corner there, and the land to the north became available. We promoted that through the local plan, sought planning permission for 600 houses, and an IKEA store to the north next to the A27, and a country park on land between the housing and the airport at Shoreham. As you'd expect, that was also hugely controversial. We had a huge amount of objection to the scheme, but in the end, notwithstanding the drainage and the flooding, highways, visual impact issues, again, we had national park issues because just to the north of 27 lies the national park, but successfully gained planning permission for that. And that's currently underway on site now. The houses are well underway. Next slide, please. Finally, I've been fortunate enough to therefore, through my connections, deal with a couple of players and their houses, Glen Murray and Solly March, to name a couple, which has been fantastic to be involved with them. We have a number of ongoing schemes with Brighton Hove Albion, both down at Lancing, the training grounds, at the football ground. There's still other things that are ongoing. This year, we've taken the stadium from the 22,000 it began with up to 28, and then up to 30, and then this year we've taken it through another planning application to 32,500. So those seats are now available. Some additional season tickets for next season, they're available at the AMEX. So there's a lot still going on, believe it or not. 20 years condensed into just over 10 minutes is difficult, but there you go, that's it. And 100 to 1 is, believe it or not, back to where we started with the betting. But we have actually made over 100 planning applications to the various authorities for Brighton Hove Albion over those 20 years, and over 100 have been granted, and just one, the hotel, has been refused. Thank you.
Thanks, Peter, very much for that, and to everyone else. Had a few direct questions in from the audience, so if I could just direct them to who I think they will be best answered by. Jonathan, can I start with you? We've got, in terms of the rent suspension clauses that you were talking about, someone's asked, what happens if there's an underlease in place as well?
Yes, that's an interesting point, because if you have an underlease, it rather depends on what the provisions are in the underlease. You might end up in a situation where the head tenant is obtaining rent suspension, even though it's getting money from its under tenant. So I have seen clauses put in place where the landlord says they won't get rent suspension if there's an underlease in place, or if there's an underlease in place where the tenant carries on paying the rent. I haven't seen very many of those, but it's in one of the main precedents people use. So it's worth thinking about the two different levels, because I can see a landlord might be quite aggrieved if it gave a rent suspension to its tenant who was merely accepting rent from an under tenant. It's another of the points you have to look at in the drafting.
Okay, thank you. Another one probably for me is if you do bring debt proceedings against a tenant, what if they can't pay? Well, I suppose that has to come into the thinking before you start the proceedings, because it's all very well getting a county court or a high court order against a tenant that they owe you hundreds of thousands of pounds, and that isn't the actual money at the end of the day, and you would need to enforce that against them. And there are various options you can pursue. But if they just don't have the finances to pay it, you have to really question whether it is worth and cost effective doing so. What was quite interesting in the cases that I mentioned where the landlords have been successful is that the court did make the point as part of its decision that the tenants who were being pursued by the landlords all had the ability to pay these arrears. They were arguing that they shouldn't have to pay them effectively because of the pandemic. So we haven't yet had a decided case, and we may never, because of the reasons, you know, I say about is it worth bringing a claim against a tenant that can't pay, but we haven't had the court considering that particular circumstance. And so from a tenant's perspective, it's got to be worthwhile explaining to your landlord, you know, if you are in arrears, your financial situation, if it's truly that you can't pay those arrears. So one more question here for Lawrence, who talked about the different routes that we potentially will have if forfeiture is abolished. It's simply, can you pursue both routes simultaneously? Thanks,
Emily. It doesn't look like it is a simple answer. As currently drafted, it seems to be a one or the other. So if a landlord goes to the summary termination route and the tenant successfully discharges that, then the landlord would have to start over and go down the standard route. So no, it doesn't look like they can do both at the same time. It's very much one or the other, it seems. Going to have to choose. Yeah. Okay. And then, as expected, a couple for Peter and his topic. So, Peter, are you going to pursue the hotel proposal, given it was nearly approved, or was there an unsurmountable problem to it?
Yeah, there was no insurmountable problem. It was a minor issue, really, of design. But the club, I don't think, have any aspiration to continue with that now. That sort of boat has sailed. But they are looking at, you know, that land is available, so they will look at future prospects for something on there that is probably more aligned to the club. But at the moment, with the pandemic, that they've sort of decided to put that on hold. So but that's something that may well come up in the future. And I'm sure there'll be a building on there at some point over the next few years. Okay, so watch that space. And another question for Peter as well. Will you and the club resubmit the planning app? Oh, it's in fact the same, very similar question. Will you resubmit the planning application for the hotel in the near future, or are there any plans for further increasing the capacity of the stadium? Okay, on the stadium, no, I think we've really milked that now as much as we possibly can within the bowl that we've got. It would need, you know, taking it to 32.5, we've really pushed every spot in the stadium. So I don't think there's any realistic option of increasing numbers more than that, or if there ever was, it would only be a few hundred. Because really where the roof is and where the pitch is, you'd have to actually be raising the roof up, which wouldn't be something that I don't think would be feasible. I think it's worth just saying as well, going back, that right at the beginning, you know, the club obviously built it initially for 22, but they knew the capacity was there. We could fill those corners in, and we could put another tier over the east stand, so we knew we could get to sort of 30. We just kept quiet about it at the time. I think the aspiration of the club was always that's where they thought they wanted to do. They wanted to do a 30,000, 32,000 stadium. They didn't want a 40 or 50,000 stadium, because they'd seen that happen with other clubs that had gone back down to the Championship, and then were, you know, like Southampton, for example, went back down to the Championship, and they might have had 15,000 in a 40,000 stadium, and it just doesn't feel right. It feels so much better if you've got, you know, 20,000 to 30,000 stadium, for example. So leaving that cap of 30 or thereabouts, I think, was part of their original thinking to maintain the atmosphere. And that's, well, I mean, obviously Brighton have been successful the last few seasons, and they've been selling out at around 30 to 32 every game. But that's probably roughly where the market is for the club. Yeah. So I think they're happy with that. Okay, great. Conscious of time, so we'll draw it to head. We always try and finish within the hour.
Just one plea from me. We've launched a post-pandemic workspace survey. So if you can spare 5 minutes, if you haven't already done so, we'd really appreciate you completing that survey. There's a link to it both on our website, and then when we circulate the slides after this webinar, you'll also receive a link to it. So we'd be grateful for that. Looking to do our next webinar in a couple of months' time, as usual. If there are any topics that any of you want us to cover, we'd be delighted to hear from you. You're very welcome to let us know, and we'll do that. But thank you again for joining us this morning. Hopefully at some point we'll see you all in person and be able to have bacon sandwiches and coffee once again. But until then, goodbye.